This week, I revisited a script where the revenge weapon is not a confrontation. It is a legal subpoena. The protagonist signs the NDA willingly, knowing that federal testimony cannot be gagged by a civil contract. The brilliance is in that gap. What NDAs cannot touch. You're watching Eternal Diary. The first thing Linnea Voss noticed when she opened her eyes was the smell of her own apartment. The particular combination of cedarwood polish and the faint sweetness of the jasmine candle she had lit 3 days ago and never bothered to blow out. That smell had not been in her life for 7 years. She had spent the last 7 years surrounded by the antiseptic bite of hospital corridors, then the cold leather of boardrooms, then the chemical stillness of the Hargrove Estate's climate-controlled rooms, and then, at the very end, nothing. She had smelled nothing at the end. Now she was here. She lay still for a long moment, cataloging the ceiling, the small water stain near the light fixture that looked like a running fox, the slightly uneven plaster she had always meant to have repainted, the morning light pressing through curtains she had sewn herself from fabric bought at a discount warehouse, because she had been 25 and 3 years out of law school and still learning what it meant to be poor in a city that performed wealth constantly and relentlessly. She was 25 again. She sat up slowly. Her hands were smooth. The small scar along her left index finger from the car accident was gone. The accident that had not happened yet. The accident that Constance Hargrove had arranged, through a man named Birch, whose real name she had not learned until the moment before impact, when she had looked in her rearview mirror and seen his face lit green by the traffic signal, and understood everything with the particular crystalline clarity of a person who has approximately 4 seconds left to live. Linnea pressed her palm flat against her thigh and felt the warmth of her own alive blood moving through her skin. She had been dead. She was certain of that. There was no dream logic in what she remembered, no gauzy imprecision. She had died on the Meridian Overpass at 11:47 on a Thursday night in February of 2024, after signing a non-disclosure agreement that her former husband's family had presented as a condition of her divorce settlement. And she had signed it because she had been exhausted and hollowed out, and she had believed, genuinely believed, that silence was the price of survival. She had been wrong about that. Silence had not been the price of survival. Silence had been the price of death. She got up and walked to the kitchen in her socks, moving through the apartment she had not inhabited for 7 years with the careful reverence of someone returning to a crime scene. The coffee maker on the counter was the cheap one she had bought at a liquidation sale. The notepad on the kitchen table still had the grocery list she had written the morning before her life changed. Milk, bread, the expensive almond butter that had felt like a small luxury, dish soap, batteries. She had been a person who bought batteries before she needed them, methodical and prepared in small domestic ways. Then she had walked into Hargrove Capital's offices on a Tuesday morning for a job interview, and she had stopped being that person. She made coffee in the cheap coffee maker and stood at the kitchen window, watching the street below. Early March, 2017. The trees on the block were still bare, their branches making precise dark lines against a white sky. A woman walked a large dog past a man reading a newspaper on his front step, and the mundanity of it was so pure, after 7 years of orchestrated elegance and performance, that Linnea felt something move through her chest. Not grief, not relief, something colder and more focused than either of those things. She had been given something impossible. She understood this. She did not spend time trying to understand the mechanism of it because the mechanism did not matter. What mattered was the shape of the next 7 years, which she carried in her memory like a map she had drawn herself, every road and cliff marked in her own handwriting. She knew the date of every conversation that would matter. She knew the names of every person who would smile at her while working against her. She knew where the bodies were buried, not metaphorically. She knew about the pension fund. She knew about the offshore routing through the Cayman accounts. She knew about the falsified NAV reports that Frederick Hargrove had been filing with the SEC since 2013. She knew because she had been the attorney who had inadvertently processed some of those documents in her first year at the firm, before she had been rotated to a different practice area, before she had married Dorian, before the information had been carefully erased from her accessible memory by the gradual architectural process of becoming a Hargrove wife. She had a job interview at Hargrove Capital in 4 days. She had been nervous about it the first time. She was not nervous now. She sat down at the kitchen table with her coffee and opened the notepad to a clean page. She wrote the date at the top. Then she wrote a single word beneath it. Infrastructure. Not revenge, not justice. Infrastructure. The word she used to describe any project that required a load-bearing structure before you could build anything visible on top of it. She was a lawyer. She thought in structures. The infrastructure she needed was simple to identify and brutally difficult to build. She needed documentation that would survive the scrutiny of a federal investigation. She needed a contact inside the SEC or the DOJ who would eventually be running the Hargrove case. Because she knew that case was coming, knew its approximate timeline, knew it would arrive like a slow-moving weather system that everyone on the ground could feel, but none of the Hargroves could see, because they had been insulated from consequence for so long that they had stopped believing it existed. She needed to position herself inside the firm before she was positioned by the firm, which was a crucial distinction. And she needed to do all of this without a single person understanding what she was building. She turned to a new page and wrote a name. Marcus Tile. Marcus Tile was a junior SEC examiner she had met at a compliance conference in Chicago in 2019, 2 years into the Hargrove's orbit. In her first life, she had spoken to him briefly, had found him clever and a little guarded, had thought nothing more of it. In the investigation that followed Frederick Hargrove's indictment in 2023, she had learned from her divorce lawyers that Marcus Tile had been the lead examiner on the Hargrove Capital case. He had built it over 4 years. He had been thorough and methodical in a way that had apparently frustrated the DOJ by its slowness. But she understood now why he had taken the time he had taken. The case he had assembled had been airtight. Every charge had stuck. He was still a junior examiner. He had not yet been assigned to Hargrove. In 4 days, she was going to walk into her job interview at Hargrove Capital, and she was going to get the job. But she was going to get it differently from how she had gotten it the first time. She wrote a second name beneath Marcus Tile's, Dara Chin. Dara Chin was a forensic accountant who had testified as an expert witness in the Hargrove trial. She had been brilliant, methodical, articulate, unflappable under cross-examination. In Linnea's first life, she had learned Dara's name from court documents she had been shown by her own divorce lawyers. Too late, when the NDA she had signed had already restricted her from participating in the case in any meaningful way. Dara worked for a mid-size forensic accounting firm in the city. In March 2017, she had been with that firm for 3 years. Linnea wrote a third name, Preston Vale. Preston Vale was her own divorce attorney from her first life. He had been the person who had explained to her, with the patient exhaustion of a man who had given this explanation many times before, that a non-disclosure agreement signed as part of a civil settlement could not, as a matter of federal law, prevent a party from responding to a valid court subpoena or grand jury subpoena. He had told her this at the moment when the SEC subpoena had already arrived, and the question had already been settled by its arrival. She did not need that information to arrive as a shock the second time. She needed it to be the foundation. She turned to a new page and wrote a fourth name, Constance Hargrove. She drew a small asterisk next to it. The asterisk meant primary target. The asterisk meant do not confuse the visible enemy with the real one. Dorian was weak and vain and had been made entirely by his mother's engineering. Frederick was greedy, in the simple, blunt way of men who have always believed that rules apply to people with less money. But Constance? Constance was the architecture. Constance was the one who had identified Linnea as a threat 6 months before Linnea had identified herself as one. Constance was the one who had arranged the NDA, and arranged the introduction to Birch, and arranged the Thursday night on the Meridian overpass. Linnea looked at the asterisk for a moment. Then she folded the page in half and held it over the candle flame on the counter until it caught, and then she dropped it in the sink and ran water over it until the ash dissolved. Paper was not infrastructure. Paper was evidence, and evidence needed to be handled correctly, or it was nothing. She had 4 days before the interview. She knew how to use them. The first thing she needed was a personal email account that had never been connected to anything Hargrove adjacent, hosted on a server that would not be subpoenaed in any of the civil proceedings that would eventually emanate from the Hargrove divorce. She needed it to be boring. The email address of a person who had nothing to hide, because the email address was specifically designed to contain nothing worth hiding. She set it up that afternoon using a library computer, creating an account she logged into once to verify, and then did not touch again for 6 months. The second thing she needed was a physical safety deposit box at a bank that was not her primary bank and was not in her neighborhood. She opened one that afternoon with $40 in cash and a secondary ID. She put nothing in it. She was not ready to put anything in it yet, but it needed to exist. The third thing she needed was to call her mother. This one was not strategic. She sat on her couch after the bank with the phone in her hand for a long time. Her mother had died in 2019, in Linnea's first life. A stroke. Quiet, not dramatic, the way her mother had lived. Linnea had not been there because she had been in Singapore for a Hargrove Capital Investor Summit, and Constance had told her, gently and firmly, that her mother's condition was not serious, and that her absence from the summit would be noticed. And Linnea had believed her. She had gotten the call from her brother at the summit dinner. She called her mother now. Her mother picked up on the third ring, her voice warm and a little distracted, and said her name the way she always had said it, slightly elongated, the second syllable landing with a particular softness that Linnea had forgotten she had been missing. They talked for 40 minutes about nothing. Her mother's garden, a cousin's new baby, the weather. When she hung up, she sat for another minute with the phone in both hands. Then she got up and went to find the interview suit she had not worn yet. The morning of the interview was gray and dry. She took the bus rather than a cab, which she would not have done the first time. The first time she had hailed a cab because she wanted to arrive composed and unhurried, and she had ended up sitting in traffic for 20 minutes growing quietly anxious. The bus deposited her 2 blocks from the Hargrove Capitol building with 11 minutes to spare. She walked the 2 blocks at a measured pace, noting the coffee shop on the corner that she would pass every morning for the next 2 years. A man in a yellow coat was reading something on his phone outside it. She looked at him and did not look away quickly, and he glanced up and their eyes met for a moment, and then both of them looked elsewhere. A small, unremarkable moment. She noticed it because she was practicing noticing everything. The lobby of Hargrove Capital was not what most people imagined when they imagined a private equity firm. There were no overt displays of wealth. The aesthetic was deliberately understated. Dark wood panels, muted carpet in a shade between charcoal and gray, a reception desk that was large but not showy, staffed by a woman named Nina who had a particular way of assessing visitors that Linnea had come to understand eventually was a skill Nina had developed over 15 years of working for Constance Hargrove. Nina assessed whether you were a threat, whether you knew things, whether you had been sent. Linnea Voss, Linnea said before Nina could speak. 10 o'clock with Howard Brennan in legal. Nina made the small adjustment to her expression that indicated mild surprise at having been preempted. She smiled. I'll let him know you're here. Howard Brennan was the head of in-house legal at Hargrove Capital. He was 53, careful, loyal to the firm in the way of men who had decided their loyalty was a fixed asset. He had hired Linnea the first time because her credentials were excellent, and her references were impeccable, and she had seemed, in the interview, to be precisely the kind of attorney who would be efficient and discreet and uncomplicated. He had hired her to be a piece of the machine, not to understand the machine. She was going to get hired again, for the same reasons. But this time, she intended to understand the machine from the first day. The interview lasted 50 minutes. She answered every question she had answered the first time with the same deliberate positioning. She was a corporate attorney with a specialty in securities compliance. She was detail-oriented, she was interested in complex regulatory environments. She had no interest in partnership track at a traditional firm. She wanted to work at the operational center of something. Howard asked about her 5-year goals, and she said what she had said the first time. She wanted to be a significant contributor to the firm's compliance infrastructure. She had not understood the dry irony of that answer the first time. She did now. At the end of the interview, Howard leaned back slightly in his chair. a gesture she recognized as meaning he was about to say something he had already decided and was framing as casual, and said, "Fredrickson Mercer reached out about you before this meeting. Strong words. You must have made an impression." "Gerald Fredrickson was a good mentor," she said. "I worked hard not to disappoint him." "That kind of reputation carries weight here." Howard closed the folder on his desk. "I'll be in touch within the week." She got the offer in 3 days. She accepted it on a Tuesday. She started on a Monday. Her first morning at Hargrove Capital had been, in her first life, a blur of introductions and orientation materials, and the particular exhaustion of navigating a new environment while performing competence. She had not retained much of it. She retained all of it now. She retained, specifically, the moment at 11:47 in the morning when the elevator doors opened on the 14th floor and Dorian Hargrove stepped out of them and nearly walked into her. He was 31. He was precisely as she remembered him. The specific way his face occupied space, the quality of his attention when he turned it on something, the automatic charm that was so well practiced it was genuinely difficult to distinguish from natural warmth. He had been charming at 25 when she had first encountered it. At 32, she was 32 now, technically, in the body that was 25, she recognized charm as a learned mechanism rather than a character trait, which gave her a particular kind of advantage. He caught himself, apologized, looked at her properly. His eyes registered interest in the practiced way of a man who had been taught that sustained eye contact was a dominance signal and not a connection signal. "New?" he said. "Corporate legal," she said. "Started this morning." "Dorian Hargrove," he said, and offered his hand. She shook it. She felt nothing except the information value of the gesture. "Linnea Voss," she said. "It's a beautiful building." That was exactly what she had said the first time. She had said it genuinely. She said it now as a precisely calibrated nothing. The kind of thing a person says when they are being professionally pleasant. The kind of nothing that takes up exactly the right amount of space and invites exactly the right kind of low-stakes follow-up. He said something about the building, something about the views from the upper floors, asked if she had been up to 17 yet. She said no. He said the view of the river was worth seeing. She smiled politely and said she was sure she'd make it up there eventually, and then she excused herself because Howard was expecting her back in the legal pod. She walked away from Dorian Hargrove on her first morning at Hargrove Capital with the particular feeling of a person who has placed a chess piece exactly where they intended it to go. The work itself was genuinely demanding. She had not been underqualified the first time, but she had been 25 and still developing the instincts that came with years of practice. Now she was technically 25 and operationally 32, and the effect was that she worked with a fluency that surprised Howard within the first 2 weeks and began to circulate quietly through the firm as a kind of mild reputation. She processed what she processed. She filed what she filed. And she read every document that passed through her hands with the compound attention of an attorney who knew that somewhere in the ordinary administrative flow of a private equity firm's legal department was the paperwork that was keeping a fraud running. She found the first indicator in her 4th week. It was a set of quarterly portfolio reports prepared for distribution to limited partners, pension funds, family offices, a small number of institutional investors. The reports contained NAV calculations, net asset value assessments of the fund's underlying holdings, that Linnea recognized because she had seen the same reports in their corrected form during the SEC investigation trial transcripts, as being inflated by approximately 12 to 15% from the actual valuations in the underlying company financials. The mechanism was elegant in its simplicity. The reports used a particular discount rate in their discounted cash flow models that was not standard. That was, in fact, lower than any reasonable market rate, which had the effect of producing higher valuations without technically falsifying any individual number. It required someone with a thorough understanding of valuation modeling to identify it, and it was the kind of thing that could survive a cursory audit without being detected. She noted it. She did not copy it. She did not flag it to anyone. She held the information in the specific part of her mind she had designated for holding things that were not yet ready to be used. She photographed nothing on company premises. She removed nothing from the building. She followed every policy in Howard's compliance manual with the meticulous care of someone who understood that any disciplinary record, however minor, would eventually be used to attack her credibility. What she did was remember. She had always had an excellent memory. After the rebirth, it seemed to have become something more. She retained specific numbers, specific language, specific combinations of figures that she could transcribe with complete accuracy hours later into the notebook she kept in her apartment, in handwriting she compressed to a size that required a magnifying glass to read clearly, on pages she tore out individually and stored in the safety deposit box. By the end of her 3rd month at Hargrove Capital, she had a physical record of 9 separate incidents of NAV reporting irregularities. The records were in her safety deposit box, in her compressed handwriting, dated and detailed. She also had 3 dinners with Dorian. The first had been effectively accidental, a firm event where seating had placed them near each other and conversation had developed naturally. The second had been his initiative, framed as casual, a group dinner that had reduced itself by attrition to the 2 of them. The third had been explicitly a date, and he had been attentive and interesting, and had listened to her in the particular way of a man who was accustomed to women performing interest rather than expressing it, and was genuinely caught off guard by someone who had actual opinions about actual things. She performed depth very well. It was not entirely performance. She was genuinely intellectually engaged with certain things he said, genuinely amused by certain qualities of his conversation. What she did not perform was a future. She did not flirt with a future. She kept herself slightly elusive, slightly resistant to conclusions, which she knew from her first life was the exact quality that had initially attracted him. He had been surrounded by people who wanted to be chosen by the Hargroves, and she had been, for whatever reason, someone who seemed not to particularly care whether she was chosen. The second time she embodied that quality from intent rather than accident, and the effect was identical. By the end of her 4th month at the firm, Dorian Hargrove was pursuing her with the methodical attentiveness of a man who has decided to acquire something. She let him pursue. She managed the pace carefully. Warm, but not eager. Interested, but not oriented. When he finally said, over dinner in a restaurant that cost more than her first month's rent, that he wanted to take her somewhere, just the 2 of them, a weekend, wherever she wanted, she looked at him for a moment with the expression she had practiced. Not coy, not calculating, something that registered as unguarded, and said she would think about it. She would think about it. It was in the 5th month that she made deliberate contact with Marcus Teal. The compliance conference in Chicago was a Thursday-Friday event in mid-October. She had attended it the first time as a fairly anonymous Hargrove Capital representative, sitting in the back row of sessions and networking in the perfunctory way of people who go to conferences for the CPD credits. This time, she attended it with specific intention. Marcus Teal was on the 2nd-day panel for a session called Evolving Examination Standards in Private Fund Reporting. He was 29, she remembered this, and he had the slightly rumpled composure of a person who had excellent judgment and mediocre patience for institutional politics. He was good at his job, in a way that was not yet fully visible to the people around him, which she knew to be his greatest advantage. He was building something quietly, the way she was building something quietly. She had recognized this quality in him from a distance in her first life, without understanding its implications. She sat in the 3rd row of the panel session. During the Q&A portion, she asked a question. Not a grandstanding question, a specific technical question about examination procedures for private fund NAV reporting that was precisely calibrated to be interesting to a competent examiner and unremarkable to everyone else. It landed in that space. 3 people around her typed something. Marcus Teal glanced at her from the panel and answered her question with a thoroughness that indicated he had actually thought about it. During the conference reception that evening, she found herself near him at the bar. She did not engineer the proximity. She allowed it, which was different. He spoke first, a follow-up to her question, a technical note he had thought of after the session ended. They talked for 40 minutes about private fund examination standards, discount rate abuse in DCF modeling, and the SEC's evolving approach to NAV verification. It was the most genuinely interesting conversation she had had in months. She gave him her card, her personal card, with her personal email, the boring, clean email address she had created at the library, not her Hargrove Capital card. He looked at it and then at her. Not your work card? I find professional relationships are cleaner when they begin outside the professional context, she said, which was true, and had the additional advantage of being exactly the kind of thing an SEC examiner would consider appropriate sourcing hygiene. He kept the card. She did not contact him again for 4 months. She needed the relationship to exist without the appearance of having been constructed, which meant she needed to give it time to be forgotten, and then re-remembered. She had learned this about trust. It was not built in a single impressive moment. It was built in the accumulation of small, unforced interactions over time, in the absence of urgency or apparent need. She and Dorian flew to Porto in November. 5 days. She had never been to Porto in her first life. It had been his suggestion, and she had been surprised by the choice, by the quieter aesthetics of it. The tile work and the river, and the particular quality of afternoon light on stone. She was less surprised the second time, but the light on stone was still what it was, which was beautiful in a way that did not require any prior life to appreciate. She let herself notice it. In Porto, she was closer to Dorian than she had allowed herself to be before. Not performed closeness. She allowed genuine moments to happen, because she understood that the most convincing version of a relationship was one that was not entirely manufactured. She let herself laugh at the thing he said on the third morning at the fish market, because it was actually funny. She let herself be moved by the dinner on the last night, by the particular quality of his attention in a context that had stripped away the social architecture of London. She also spent 40 minutes on the second afternoon while he was napping, photographing her own handwritten notes in her compact notebook with her phone. Not because she needed the photos, she remembered everything, but because she was practicing the mechanics of discretion, the habit of documentation, the muscle memory of building a record. She fell a little bit in love with Porto, and not at all with Dorian, and returned to London carrying both of those facts with the same neutral acknowledgement. By December, she had moved the relationship to the point where meeting his family was the natural next step, which was the step she needed to take because the next phase of her documentation required access to the family's internal social architecture. She needed to meet Constance. Constance Hargrove was 61 and had the physical bearing of a person who had never once walked into a room without having designed her entrance. She was not an aggressive presence. That was important to understand. She was an architectural one. She organized social space around herself with the effortlessness of a person who had been doing it for 40 years, so that you understood the power structure of any room she occupied without being able to identify the specific moment when you had come to understand it. She received Linnea at the family's Kensington house on a Saturday afternoon in December, with Frederick and 2 family friends whose presence served the function of distributing the pressure of the evaluation across multiple conversational contexts. Constance herself was warm, direct, and attentive, in a way that felt entirely genuine, and that Linnea knew, from the specific wisdom of having been on the other side of this attentiveness for 3 years, was a form of assessment more thorough than any interview she had encountered. Constance was looking for the thing that would eventually become a liability. In her first life, Linnea had not known she was being evaluated. She had been charmed and flustered, and had projected a warmth that Constance had likely read accurately as the openness of a person who had not yet learned to protect herself. This time, she projected warmth of a different kind, still genuine in its performance, but constructed with specific guardrails. She agreed where she genuinely agreed. She demurred where demurring was strategically useful. She was interested in Constance without being curious, which was a crucial distinction that took her 2 practice dinners with colleagues to calibrate correctly. Interest said, "You matter to me." Curiosity said, "I'm trying to understand you." Constance did not want to be understood. She wanted to be acknowledged as someone who had already understood you. Linnea gave her acknowledgement, and nothing more. On the drive home, Dorian said his mother had liked her. "She's formidable," Linnea said, which was true. "She is," he said, in a tone that carried the complex weight of a man who had been shaped by a formidable woman, and was neither grateful nor resentful about it in any simple way. She spent Christmas with her own family. She spent New Year's with Dorian and 3 of his friends at a house in the Cotswolds, that belonged to someone else. She spent the first 3 months of 2018 working at Hargrove Capital, with the focused attention of a person who is building something that will not be visible until it is finished. By March 2018, she had 17 documented instances of NAV irregularities. She had also identified the mechanism by which the falsified reports were generated, a proprietary valuation model maintained by a senior analyst named Gareth Plow, who she was now reasonably certain was aware of the irregularities, and had been since the model's inception. Gareth Plow was not a target. He was a component. She noted him in her records without emphasis. In March, she received an email from Marcus Teal. It was brief, professional, a note referencing the conference session from October, and a paper that had subsequently been published on NAV examination methodology. He thought she might find it useful, given her work context. He was right. It was useful. She replied 3 days later. She thanked him for the paper. She mentioned a specific technical detail in it that she found interesting. She did not mention Hargrove Capital. She did not mention the irregularities she had been documenting for 10 months. She responded as a person who had a professional interest in the subject and was maintaining a collegial connection. Nothing more. They exchanged 3 more emails over the following 6 months. Each one was about regulatory standards. Each one was sent from her personal email address. None of them contained anything that was actionable for either party. She was building trust with a time horizon of years. In June 2018, she and Dorian began seriously discussing marriage. She had let this unfold at exactly the pace it had unfolded in her first life, because any acceleration would have been visible to Constance, and any deceleration would have required explanations. They were engaged in September. The announcement was made through appropriate channels. There was a dinner at the Kensington House that Constance hosted with the particular graciousness of a person who had already decided the outcome months before it was announced. Linnea wore the ring. It was a significant object. She wore it with the care of a person who understands that significant objects are also loaded weapons. The 6 months between the engagement and the wedding were the most technically demanding period of the plan. She was now embedded in the family's social and operational structure in a way that gave her access to information she had not had as an employee. Family dinners, conversations between Frederick and Dorian that would not have happened in a boardroom, the particular landscape of the family's financial anxieties, which were more acute in 2018 than they had been willing to appear from the outside. She knew this because the SEC examination that would eventually break the case had begun in late 2017 as a routine review, and by mid-2018, it had shifted from routine to targeted, without the Hargroves fully understanding the shift yet. She knew this because Marcus Teal had sent her a paper about how examination scope determinations were made. It was a publicly available paper. It was also a specific enough paper that only a person paying close attention to examination procedures would find it relevant. She read it twice and noted 3 paragraphs that she suspected referred, in their generalized academic language, to the kind of scope expansion that would be triggered by what she had been documenting. She was not the source that had triggered the scope expansion. She had not yet given Marcus anything. She did not need to be the source. The SEC examination had its own momentum. All she needed to do was continue building her record until the moment arrived when she could hand it to the right person, in the right format, at the right time. The wedding was in April 2019. It was a large event, controlled in every detail by Constance. Linnea wore a dress she had chosen herself, had fought a small, quiet battle about it, had won. The dress was not extraordinary. It was elegant in a way that required some looking to appreciate, which was how she wanted to be dressed at a Hargrove event. She wanted to look like a person who did not need to be looked at. Her mother came. She held her mother's hand before the ceremony in the room where she was waiting, and her mother looked at her face and said, "You seem so calm." "I am," Linnea said. "Is that good?" "I think so." Her mother was still alive. This, more than anything else, was the thing she was doing this for. Her mother was still alive because it was 2019 and not 2021. And what Linnea was building was a structure that would, when it was finally triggered, end the Hargrove family's ability to hurt anyone connected to her. She was building it for her mother, who did not know she was doing this and could not know, and who would live to see its completion. The first 2 years of the marriage were, She had no cleaner word for it. Strange. She moved through the life she had lived once before with the double consciousness of someone watching a film they had seen and knowing precisely when each scene was coming, which had the paradoxical effect of making some things hurt more sharply rather than less. She knew when Dorian's kindness was genuine and when it was performed. She knew when Constance's warmth was strategic. She knew the shape of the house she was living in, and knowing it meant she saw its architecture in full, which was not pleasant to see. Frederick Hargrove was, in private, a man who rarely spoke about money directly. He spoke in the coded language of a person who had made enough money that money had become a form of weather. Something you moved through rather than accumulated. Something that shaped the environment without ever being acknowledged as a presence. Dinners at the family house were about art, politics, property. They were never about the fund. They were never about NAV calculations or quarterly reports or the SEC. In January 2020, over a Sunday lunch, Frederick mentioned that the firm had been through a fairly thorough regulatory review and had come out well. He said this in passing, as one mentions a minor inconvenience that has resolved itself. Linnea looked at her plate and said nothing. She knew the review he was referring to was Marcus Teal's examination. She knew the examination had not been resolved. It had been paused. The examiner had requested additional documentation that had not yet been fully provided, and the pause had been engineered by the firm's external counsel as a delaying tactic. She knew this because in January 2020, she had had her first in-person meeting with Marcus Teal since the Chicago conference, at a public lecture on securities regulation at a law school event that she had attended in her personal capacity and that he had also attended. They had spoken for 20 minutes in the lobby afterward. He had said nothing about Hargrove Capital. She had said nothing about Hargrove Capital. She had said, in the context of a conversation about examination delays, "I've been thinking a lot about the patterns in delayed documentation responses. It always interests me which types of firms deploy that strategy most frequently and what the documentation they're delaying tends to cover." She had said it in a tone so neutral and academic it could have been unprompted professional musing. Marcus Teal had looked at her, for one moment, two, with the expression of a man who was performing the calculation she had hoped he would perform. Then he had said, "Historically, the most meaningful delays tend to cluster around valuation methodology. DCF model inputs specifically." "Specifically," she said. They did not say anything more about it. They exchanged pleasantries, parted ways, and she walked to the subway with the careful composure of a person who has just placed the keystone of an arch. She did not contact him again for 8 months. The marriage deteriorated in the way that she had known it would deteriorate. Dorian's character, separated from the performance of courtship, was not unkind. It was simply hollow, in the specific way of a person who had been shaped by a powerful parent into a reflection of that parent's values, without ever developing a value system of his own. He was not cruel. He was negligent, in the way that a person is negligent when they do not actually believe that anyone else in their environment has an interior life that is as real or as significant as their own. She did not fight with him. She had fought with him in her first life, progressively and destructively, and the fights had been exhausting and pointless, and had ultimately been used against her in the divorce proceedings as evidence of an unstable temperament. This time, she was pleasant. She was consistent. She was a wife who appeared, to anyone looking from outside, to be managing her marriage with the kind of competent equanimity that was entirely above reproach. She was also, in October 2020, quietly contacted by a lawyer she did not recognize. The email arrived in her personal account, the clean one, from an address she did not immediately identify. It was brief and professional. The writer was a counsel associated with a federal investigation and would like to speak with her at her convenience. No specifics. No case name. A phone number and an office address. She cross-referenced the office address. It was a DOJ field office. She sat with this information for 48 hours before responding. She needed to be certain of two things: that the contact was genuine and that responding did not create any record that would be visible to the Hargroves before she was ready. She used a borrowed phone at a location that was not her home or office to call the number, which answered on the first ring, and confirmed the identity of the contact. His name was Arnaud Weiss. He was a trial attorney in the fraud section. He had been working with the SEC examination team, with Marcus Teal's team. "I need to know a few things before we speak substantively," she said. "Of course," he said. "First, is this a target communication or a witness communication?" "Witness," he said. "Entirely." "Second, if I speak with you, does any record of that communication reach the firm's external counsel before I am prepared for it to do so?" A brief pause. "We would have no reason to share witness communications with opposing counsel." "Good," she said. "Then I'd like to meet." She met with Arnaud Weiss on a Thursday morning at a coffee shop she had chosen for the specific reason that it was 3 miles from her home, on a street she never walked, frequented by no one she had ever been seen with. She arrived 13 minutes early and sat at a corner table with her back to the wall, and a coffee she had ordered but did not intend to drink. Arnaud Weiss was 46, compact, precise in his movements, and speech in the way of a person who had spent 20 years in rooms where every word counted. He sat down, ordered water, looked at her with the practiced, neutral expression of a federal attorney conducting a first contact. She handed him a sealed envelope. He looked at it. "What is this?" "A summary," she said. "Not the documentation. The documentation exists separately, in a form that your forensic team will want to see. What's in the envelope is approximately 3 years of observed irregularities in the fund's NAV reporting methodology, summarized in sufficient technical detail to confirm that what you're looking for is there, and that the person describing it to you has the specific knowledge to be a credible witness." He opened the envelope. She watched him read. He read for 4 minutes. His expression did not change. "When can we see the documentation?" he said. "When I am protected," she said. "Specifically, when I have, in writing, a clear articulation of my status as a cooperating witness with immunity for any civil claims that could be asserted against me relating to the period of my employment, and when I understand the timeline for the investigation in sufficient detail to manage my position accordingly." "That's a reasonable ask," he said. "I know," she said. They met 4 more times over the following 3 months. By January 2021, she had a signed cooperation agreement. By February, Arnaud Weiss and Marcus Teal had reviewed the safety deposit box contents. 5 years of compressed handwritten notes, which Dara Chin's forensic accounting firm had been engaged to translate into an expert analysis. The analysis ran to 97 pages. It identified 43 discrete instances of NAV inflation across 8 years of fund operations, documented to a standard that would survive the most rigorous evidentiary challenge a defense team could mount. The investigation that had been building since 2017 had its keystone. She did not tell Dorian. She did not tell anyone connected to the Hargroves. She continued going to work, going to family dinners, wearing the ring, being a Hargrove wife. She continued being unremarkable and above reproach. In March 2021, Dorian came home one evening with the particular quality of distraction that she recognized from her first life as the prelude to a significant conversation. She recognized it now the way she recognized everything in this house. Precisely, without surprise, without the uncertainty that had once made these moments frightening. He sat down across from her in the sitting room. He had a glass of something amber. He looked at his glass for a moment before looking at her. "I've been speaking to some people," he said, "about our situation." She kept her expression exactly where it was. "Our situation," she said. "Things haven't been... I think we both know that things haven't been what they should be." He was doing the thing he always did when he was uncomfortable, slightly pulling at the cuff of his left sleeve. "I think it would be better for both of us to discuss a separation." In her first life, this had devastated her. She had argued, wept, bargained, and then been systematically dismantled over the following 6 months by a team of Hargrove lawyers who had been preparing for this conversation since before Dorian had it. She had ended up with a settlement so small relative to the estate's assets that her own lawyer had described it as a nominal gesture, and attached to that settlement had been a non-disclosure agreement that covered the entirety of her knowledge of and involvement with Hargrove Capital's operations. This time, she set down the book she had been reading and looked at Dorian with the level attention of a person who had already processed this moment. "All right," she said. He blinked. He had been prepared for something else. "All right." "If that's what you think is best," she said. A pause. "We should discuss." "I know we should," she said. "I'll have my lawyer reach out to yours this week. I'd like it to be clean and civil if that's possible." He looked at her with a flicker of something she recognized as unsettled. Not guilt, precisely, but the discomfort of a person who has rehearsed a difficult scene and has had the other actor decline to play their part. "Yes," he said after a moment. "Of course. Clean." "Good," she said. She picked up her book again. She called Preston Vale the next morning. He was, in 2021, a well-regarded family law attorney with a particular expertise in high-asset divorces. She had found him in her first life through a referral. Too late, after the Hargrove lawyers had already established the framework. This time she called him first. She sat in his office on a Tuesday and explained her situation. He listened to a woman who seemed calm, systematic, and exceptionally clear about what she wanted, which was not what most of his high-asset divorce clients presented as. He listened. He took notes. "The asset question is going to be complicated," he said. "The marital estate is significant, but if the firm's valuations are..." "The firm's valuations are false," she said, in the same tone you would use to note that it was raining outside. "That's a matter of ongoing federal investigation. I am a cooperating witness in that investigation. I have a signed cooperation agreement with the DOJ fraud section." Preston Vale looked at her for a long moment. "Since when?" "Since January." Another pause. "And the Hargroves don't know?" "No," she said. He sat back in his chair. "Then the NDA..." "Let them offer it," she said. "I will sign it. I want you to understand that I will sign it fully understanding that it cannot and will not prevent my testimony in a federal proceeding." He was quiet for a moment, working through the structure of it, the way the civil NDA interacted with federal subpoena authority, the specific provisions of federal statute that govern the relationship between private agreements and official proceedings. "Under 18 U.S.C. 1512, she said, gently, to save him the work. "Right," he said. "Right." He looked at her with an expression that was professional, but that she could see contained something closer to admiration. "You're going to let them think they've shut you down?" "I'm going to sign their NDA," she said. "And when the subpoena arrives, I'm going to comply with it fully, because I am legally required to do so, and because complying with it fully means testifying to everything I know." "And the attempted enforcement of the NDA against your testimony," he said, following the logic, "would be..." "Witness tampering at minimum," she said. "Obstruction of official proceedings, potentially a RICO predicate act given the context." She looked at the framed diplomas on his wall, with the mild appreciation of someone who understands the context in which credentials matter. "Constance Hargrove is going to send a lawyer to warn me off testifying the moment she learns about the subpoena. I need you to have a very specific response ready when that happens." "Tell me what you need," Preston said. She told him. It took 40 minutes. When she finished, he closed his notebook and looked at her with the expression of a man who is recalibrating his understanding of a situation. "Miss Voss?" he said, and the shift from her married name was seamless, deliberate, already accomplished before it was official. "Either is fine," she said. "For now." The divorce proceedings began in April 2021. They proceeded, from the Hargrove side, with the systematic efficiency of a legal team that had done this before. The family's lead attorney was a man named Clifford Hayes, who was 64, experienced, and who had managed the family's legal exposure across 3 decades of the kind of decisions that required managing. He was very good. Linnea watched him work from across the table at preliminary conferences, with the respectful attention she would have given any competent opponent. Constance appeared at 2 of the early settlement discussions. She was, as she always was, architecturally composed. She sat at the table with Frederick, and Dorian arranged beside her, in the specific configuration that communicated hierarchy without stating it, and she spoke when she chose to speak, which was rarely, and when she did, it was precisely and without embellishment. She looked at Linnea occasionally in those meetings with the expression of a person who has already decided the outcome and is managing only the timeline. Linnea returned these glances with a warm neutral that contained nothing. The NDA was introduced in May as part of the settlement package. The Hargrove lawyers presented it alongside a financial settlement offer that was, as in her first life, considerably below any reasonable calculation of her marital interest. They were, she understood, deliberately keeping the settlement below the threshold that would trigger serious pushback, hoping she would accept it with the NDA because she did not understand the NDA's limits. Preston reviewed the NDA and confirmed what she already knew. It was broad, professionally drafted, and would have been entirely effective at silencing her in any civil context. It covered all aspects of her knowledge of or experience at Hargrove Capital, the family's personal financial affairs, and the management of the fund. It specified substantial financial penalties for any breach. It was, in the language of a document that intended to be comprehensive, comprehensive. It said nothing about federal subpoenas. NDAs never did. It would have been legally meaningless to include such a provision. The law was clear, but the absence of the provision was the kind of thing that required specific legal knowledge to identify as significant. Clifford Hayes had presumably calculated that Linnea would read the document, see its breadth, feel its weight, and conclude that she was comprehensively silenced. She signed the NDA on a Thursday morning in June 2021. She signed it in the conference room at Preston's office, in front of Preston and Clifford Hayes, and one of Clifford's associates. She signed it with the gold pen they provided, and she set the pen down and looked at Clifford Hayes with an expression of neutral finality, the expression of a person who has accepted their terms. Clifford Hayes looked back at her with the practiced warmth of a lawyer who has just completed a favorable settlement. "We appreciate your cooperation," he said. "Of course," she said. She collected her copy of the signed agreement and followed Preston out of the conference room. In the elevator, Preston faced forward and said nothing until the doors closed. Then he said, "How long until the subpoena?" "If the timeline holds," she said, 8 to 12 months. "Grand jury or trial?" "Trial. The indictment should come first. Then the subpoena in the trial prep phase." "And you're comfortable with the cooperation agreement's protection for the interim?" "I am," she said. The elevator reached the lobby. They walked out into the street, into a gray afternoon that smelled of rain on warm pavement, and she paused on the sidewalk for a moment. Across the street was a coffee shop. A man in a yellow coat was reading his phone outside it. She had seen a man in a yellow coat outside a coffee shop before, on the morning of her first Hargrove interview, 4 years ago. 4 years from now. She could not be certain it was the same man. It did not matter. She felt the coincidence of the image as a particular kind of punctuation. The story closing a loop she had not planned to close. "Good," she said, to no one in particular. Then she put on her sunglasses and walked to the subway. The indictment of Frederick Hargrove came in February 2022. It was sealed initially, which meant the family did not know about it for 11 days. Those 11 days were the only period during which she experienced something close to anxiety. Not about the outcome, which she knew, but about the gap between knowing and seeing. The way the interval between the thing being true and the thing being visible was always its own kind of suspense. She was no longer Linnea Hargrove by then. She had reverted to Voss immediately upon finalization of the divorce in September 2021. She had moved back to an apartment she had found herself, in a neighborhood she had chosen herself, furnished simply and practically in the way of a person who has given up performing wealth, and is not performing simplicity either. She had gone back to working as an attorney, not at a firm but as a consultant, leveraging her compliance expertise in a way that kept her close enough to the regulatory environment to maintain her knowledge base without creating any conflicts of interest that would complicate her role as a cooperating witness. She had a small, clean life. She had dinner with her mother once a week. She had 3 friends from her pre-Hargrove years who had not been entirely discarded by the marriage because she had maintained those relationships with more deliberate care in this life than she had in her first one. She went to bed at a reasonable hour. She did not think about the Hargroves every day. She thought about them on the days when she needed to, which was enough. Constance called her in March 2022, 3 weeks after the indictment became public. It was the only call Linnea received from any member of the family after the divorce. She answered it because she had been waiting for it. Constance's voice was what it had always been, controlled, modulated, warm in a way that was entirely technical. "Linnea," she said, "I imagine you've seen the news." "I have." Linnea said. "I'm calling as a courtesy," Constance said, "to remind you that you are bound by the terms of the agreement." "I'm aware of the terms of the agreement," Linnea said. She was standing at her kitchen window. The trees on the block had their leaves in March, bluer green than the park trees further down the road. She noticed it now, the way she noticed everything now. "The terms are clear," Constance said. "You know that any disclosure would carry significant consequences." "I know the terms," Linnea said. "Was there something else?" A pause, short but detectable. "I hope you'll be careful," Constance said. "I'm always careful," Linnea said. "Thank you for calling, Constance." She ended the call and set the phone on the counter. She did not feel triumphant. She felt the particular quality of a person who has prepared for every weather and is watching the predicted storm arrive exactly when and in exactly the form they expected. The call was the basis of a supplemental report she sent to Arnold Weiss that afternoon, documenting the attempt to use the NDA to deter her potential testimony. She had recorded the call. She had been recording all calls from Hargrove-adjacent numbers since before the divorce, under a single-party consent recording provision that was applicable in her current jurisdiction and that Preston had confirmed was legally sound. The recording was time-stamped, clean, and added to the cooperation file. Clifford Hayes' firm sent a formal letter in April 2022, delivered to Preston's office, referencing the NDA and making explicit reference to the pendency of the criminal proceeding against Frederick Hargrove. The letter did not explicitly state that she should not testify. It was more careful than that, but it referred to her obligations under the settlement agreement and invited her to contact their office to discuss any inquiries she might receive in connection with ongoing legal matters. Preston responded the same day. His response was 4 paragraphs. The 4th paragraph cited 18 U.S.C. Section 1512 and noted that any further communications of this nature would be preserved and provided to the relevant federal authority as evidence of potential obstruction of official proceedings. There were no further letters. The subpoena arrived in July 2022. It arrived at Preston's office, as she had arranged with Arnold Weiss, directed to her personally as a material witness in the United States versus Frederick Arthur Hargrove matter. It was a 6-page document, clean and specific, and it directed her to appear and provide testimony and to produce any documents in her possession relevant to the matter. She had documents in her possession. She had had them for 5 years. She had been building the set of documents for 5 years, with the specific intention of producing them at exactly this moment. Preston sent a copy of the subpoena to Clifford Hayes' firm the same day it arrived, with a brief cover letter noting that Ms. Voss would be complying fully with its terms. There was a 48-hour silence from the Hargrove side. Then Clifford Hayes called Preston, and the conversation that followed, which Preston relayed to her in careful, professional language, was the conversation of a man who understood that the architecture of his client's protection had just been revealed to have a significant structural gap. "He wants to discuss the parameters of compliance," Preston said. "There are no parameters," she said. "I received a valid subpoena. I will comply with it fully." He's suggesting that the testimony could be limited to— "The subpoena is not limited," she said. "I will comply with the subpoena as issued." Preston was quiet for a moment. "He mentioned litigation risk." "He can mention it," she said. "He knows, and I know, that initiating civil litigation against a federal witness for complying with a subpoena would be inadvisable." "He knows," Preston said. "I think the call was more of a final attempt at leverage than a genuine legal position." "Then we don't need to do anything more," she said. The trial of Frederick Arthur Hargrove on 17 counts of securities fraud, 2 counts of wire fraud, and 3 counts of filing false statements with the SEC began in November 2022. The courtroom was full on the first day, in the way that financial fraud trials are full. Not with the general public, which does not follow financial fraud trials closely, but with the specific community of people for whom the case mattered. Journalists from the financial press, attorneys from firms that had been circling the case, representatives from the pension funds whose beneficiaries had been carrying the weight of the Hargroves' manufactured numbers for 8 years. Linnea Voss testified on the 4th day of trial. She had been prepared by Arnold Weiss and his team over 3 separate sessions, each lasting several hours. The preparation had the texture of a highly specific rehearsal. Not scripted, because scripted testimony was always detectable, but structured. She understood which questions she would be asked, what the defense's cross-examination strategy was likely to be, and how to give testimony that was accurate, specific, and unambiguous, in the way that only testimony from someone who had been present and paying careful attention could be. She was not nervous on the morning of her testimony. She was what she had been for 5 years. Prepared. She wore gray, a simple suit, well made but not conspicuous. The kind of clothes that said, "This is a person who came here to do a job, not to perform." She sat in the witness chair with the physical composure of a person who has been in rooms like this one many times before, and finds them neither intimidating nor comfortable, but simply functional. Arnaud Weiss began with foundational questions. Her name, her professional background, her employment at Hargrove Capital, her role in the legal department, her marriage to Dorian Hargrove, her subsequent divorce. She answered each question with the clean precision of a person who has nothing to hide and nothing to embellish. Then the questions moved into substance. She described the NAV irregularities she had first observed in October 2017. She described the specific mechanism, the below-market discount rates in the discounted cash flow models maintained by Gareth Plow, which produced inflated valuations that were then reported to limited partners as the fund's actual performance. She described the 17 instances she had documented in her first year, and then the additional 26 instances she had documented over the subsequent 4 years, totaling 43 documented irregularities, each of which had been analyzed and verified by Dara Chin's forensic accounting team. She described the amount by which the fund's reported performance exceeded its actual performance, an average of 13.4% annually over a period of 8 years, across a total invested capital base of approximately $4.3 billion. She was specific. She was accurate. She was not dramatic. She answered each question with the quality of a person who is describing things they have seen clearly because they had been positioned from the beginning to see them clearly. Clifford Hayes' co-counsel conducted the cross-examination. He was good. A younger attorney named Barlow who had the aggressive precision of someone trying to establish himself. He attacked her credibility along 3 axes: her financial interest in the outcome, her professional judgment in remaining at the firm without raising concerns, and the reliability of her memory across 5 years of events. She answered each line of attack with the same quality she had maintained throughout. On the financial interest question, she noted that her divorce settlement had been reached before her cooperation agreement, that the cooperation agreement carried no financial incentive beyond immunity from civil claims, and that she had retained and preserved documentation contemporaneously, not from memory alone. On the professional judgment question, she noted that the observations had required specific technical knowledge of DCF modeling to identify, that she had documented them as she identified them, rather than raising them through channels controlled by the individuals committing the irregularities, and that she had reported them to federal authorities at the earliest point at which she could do so, with her own legal position protected. On the memory question, she said, "I kept records. I have records. The records are in evidence." Barlow returned to the NDA. "You signed a non-disclosure agreement as part of your divorce settlement," he said. "Yes," she said. "That agreement covered your knowledge of Hargrove Capital's operations." "It did." "And yet, you are here." She looked at him with the patient expression of a witness who has anticipated this exchange and finds it neither threatening nor particularly interesting. "I am here because I was served with a valid federal subpoena requiring my testimony," she said. "A non-disclosure agreement signed as part of a civil settlement cannot prevent compliance with a valid court order. This is well-established federal law." "You were aware of that at the time you signed the NDA?" "I was," she said. "Yes." A pause in the courtroom. Not a long one, 5 seconds, but the kind of 5 seconds in which everyone present is processing the same thing, which is that the witness has just confirmed, clearly and in open court, that she signed a document knowing it would not prevent her from being where she is right now. The defense attorney looked at his notes. He moved on. She testified for 4 hours and 27 minutes. At the end of the cross-examination, Arnaud Weiss conducted a brief redirect, covering 3 points that Barlow's cross had left imprecise. When he was finished, the judge thanked the witness, and she stepped down from the stand. She walked back through the courtroom to the gallery exit. Frederick Hargrove was seated at the defense table in the configuration of a man who has spent several months watching his options close and is now watching the last one close. He did not look at her. Dorian was not in the courtroom. He had been advised by his own counsel to stay away, and he had. Constance was in the gallery. She had been allowed to attend as a family member, though she had been excluded from the proceedings themselves because she was a listed potential co-conspirator. Constance watched Linnea walk toward the exit, with the expression of a person watching a building they constructed being demolished. Not a dramatic expression, a still one. The expression of a person who is accepting a thing that cannot be changed, because acceptance is the only form of control that remains. Linnea met her eyes for 1 second, not as a gesture of triumph, not as a message, simply because Constance was there, and looking away would have been its own kind of communication, and she had nothing left to communicate to Constance Hargrove. Then she looked away, pushed open the door, and walked out into a corridor that smelled of government-issue cleaning fluid and carpet that had absorbed decades of people waiting for things to be decided. She kept walking. Frederick Hargrove was convicted on 14 of 17 counts in January 2023. The sentencing, in March, carried 7 years with eligibility for supervised release at 5. The firm's assets were frozen, pending civil recovery proceedings for the pension funds, whose losses had been assessed at approximately $560 million. The accounting of those losses and the methodology by which they had been concealed appeared in the forensic analysis that Dara Chin had built from Linnea's notes. The notes in the compressed handwriting in the safety deposit box, the notes she had begun writing in the first weeks of her second chance at a life she had decided not to waste on anything that wasn't infrastructure. The Hargrove family's legal exposure did not end with Frederick's conviction. Constance was indicted separately in April 2023 on 2 counts of obstruction related to the attempt to use the NDA to prevent Linnea's testimony. The evidence for those counts included the telephone call Constance had made in March 2022, the recording of that call, and the letter from Clifford Hayes' firm that Preston had responded to with his citation of 18 U.S.C. Section 1512. Constance entered a plea agreement in September 2023. 3 years, suspended, with significant financial penalties. It was less than Linnea had once, in a different life, imagined satisfying. But satisfaction had never been the metric she was measuring against. The metric was, had the structure held? Had the load-bearing elements of what she had built over 5 years, the documentation, the cooperation agreement, the subpoena compliance, the testimony, each performed exactly the function she had designed them to perform. The structure had held. She was in her apartment when the Constance plea was confirmed, sitting at the kitchen table, with coffee in the cheap mug she had kept across every version of her life. She read the news item on her phone and set the phone face down on the table and sat with the particular quality of a morning that is simply a morning. No architecture required. Nothing to build, nothing to document. The trees on the block outside had their full leaves in September, and the light through them had that quality she had first noticed in Porto years ago, which was the quality of light that asks nothing of you, except that you see it. Her phone buzzed. A message from Preston. "Well done. That's it." She did not reply immediately. She finished her coffee. She refilled it. Then she picked up her phone and called her mother. It rang twice before her mother answered, her voice warm and a little distracted, the way her voice always was at this hour. She said Linnea's name the way she always said it, the second syllable landing with a softness that Linnea had first relearned to hear in March 2017, on a morning when she had woken in her own apartment smelling cedar polish and jasmine, and had understood that she had been given something she intended to use correctly. "Hi, Mom," she said. "I was just about to call you," her mother said. "The beans have gone completely out of control. You have to come see them. Come for lunch." "Yes," Linnea said. "I'll come for lunch."